Welcome to the Rachele and Cassandra show. Before we begin, our disclaimer. These bitches sound like they're giving legal and financial advice, but I promise you they're not.
Welcome, everybody. Thank you for joining me today. I'm Rachel Evers, your glorious host of the Rachele and Cassandra show. Here today, I have a guest that I'm honored and kind of nervous to have in studio with me. I want to say like my good friend, but you're not really my good friend, but you are my attorney.
Sure.
Chris Berry from Castle Wealth.
Yes.
Formerly known as
The Elder Care Firm.
The Elder Care Firm. That's who you were when I hired you.
Yes.
So I have a nice checklist of stuff that I want to talk about with you as it pertains to real estate. My hope with this episode is to dispel some of the myths that people have, especially, I'm a real estate professional, and dealing with people's estates while they're still alive, if they haven't taken care of things after they've passed away, can create real problems if you don't have these conversations ahead of time. So let's start with this. Who are you and what qualifies you to have this conversation with me?
Well, I stayed at a Holiday Inn once, so I feel like I know some things. No, just kidding. I
like it.
Yeah. So I'm an estate planning attorney and certified financial planner. So we help clients kind of deal with planning for the rest of their life and then what type of legacy they leave. And so I've been doing this for about 16 years, and we do a lot of real estate as part of putting together a comprehensive estate plan for a client. We probably record over 200 deeds a year. And so I've seen a lot of things in terms of good planning. I've seen a lot of bad planning. We focus more on the planning ahead, trying to prevent the messes when someone passes away or someone becomes incapacitated versus cleaning up the messes and going to court. Like I try to keep people out of court at the end of the day. So been doing this about 16 years. And like I said, we probably record upwards of 200 deeds for real estate per year.
So when you were, going off to college, were you like, hey, Mom, I want to be an estate planning attorney? Like, how do you get here?
Sure. Well, I wanted to be in the NBA, a basketball player.
Is that like authentic?
Yeah.
Yeah. Oh, no, I love it.
But when I was 12, I stopped. I realized I wasn't going to make it to the NBA, so I had to figure something else out. No, I had no idea what I wanted to do when I grew up. My dad was a psychology professor, and I had a psychology class in high school. I was like, oh, this is kind of cool. And then my mom had a finance MBA, and she worked in a supply chain company. And so I ended up going to Grand Valley. I got in the honors program there, and so I ended up going there, but I didn't know what I wanted to do. And so I took some psychology classes. I was like, oh, I really like the psychology stuff. I like to understand what makes people tick. But I knew I didn't want to become a psychology professor. And I was like, what else can I do with a psychology degree? Not much. And so I got a finance major as well. So I have a kind of weird dual major of finance and psychology.
It's an interesting combination.
Yeah. And as I was going through my finance track, I had a business law class I just knocked out of the park. And I was like, let me try this law school stuff. Like, I didn't know any lawyers growing up. I never wanted to be a lawyer. And I realized very quickly I didn't like going to court. My first summer I spent at the Wayne County Prosecutor's Office on the major drug unit. And we're on the, so I was the good guys, but I just didn't like the arguing. I didn't like the fighting, the conflict. It wasn't for me. So I knew I didn't want to go to court, and I think it's kind of silly and argumentative and not logical.
It's like an organized argument.
Exactly. Yeah. And I don't like conflict. So it's like, what can I do as a lawyer other than go to court? And so I knew I wanted to do something more transactional. And so I went to Michigan State Law School, and I got a corporate concentration. So really focusing on more of the transactional side of being a lawyer. And coming out of there, I got a job at a supply chain company reviewing carrier contracts.
Carrier? Contract, is that what you said?
Yeah.
Okay.
They would contract with like mom and pop, like shipping companies to get stuff from point A to point B, and I would review the contracts. And if they weren't following the contract, I'd have to like follow. It was like a Dilbert type life.
I like that reference.
It paid well. I was able to pay off some student loans pretty quick, but I realized that's not what I want to do. So while I was there, I was plotting like, what's my escape? And I was looking at all these different areas of law. Like, do I want to do criminal law? Because I had history with a assistant prosecutor. And I was like, oh, this isn't what I want to do. And I identified estate planning.
Are you still, at this point in your life, are you like in your 20s?
Yeah. Yep.
Okay.
No, so I was mid-20s. So
Okay.
I was just out of law school. My first year, I was at that supply chain company. And like about 6 months in, I knew I was like, this is not what I want to be doing. And so while I was there, I was kind of plotting my escape, and I was attending workshops and studying to get up to speed on estate planning. And I identified estate planning as the area that I wanted to practice, because of my background of finance and psychology, which makes a lot of sense. That's really what we're dealing with, is like people and money and stuff.
It's like a brilliant combination.
Yeah.
Really.
And I didn't plan it this way. I just kind of backed into it. But I identified estate planning because my background seems to lend to it. B, you're just helping people. Like, you're just sitting down with good families, helping them plan, protect, and preserve what's important to them. And then C, from a quality of life standpoint, which is always very important to me, like, there's no huge emergencies in estate planning. Like, sure, people pass away, but you have to wait for death certificates and things happen, versus being a criminal law attorney. Like, I have to have my phone on me and I might get a call at any time, versus in estate planning, if I want to be out, right now I leave work at about 3:30 Monday and Tuesdays because I'm coaching my kids in soccer.
Yeah.
Like, I don't have to worry about a judge telling me I need to be here or there.
So when I get arrested and go to jail, you're not my attorney that I'm calling?
No, unless
Good
I
to
saw
know.
unless I saw in Law and Order last night, it's probably not going to be good.
Okay.
Yeah. Yep. So I identified estate planning as the area that I wanted to practice, and now 16 years later, still doing it. And we've kind of branched off to not just think of estate planning as planning for what happens if you die. We do that, but also I started doing what's called elder law, which is planning for what happens if you don't die, what happens if you need long-term care, dealing with asset protection, protecting resources. And then we added in financial planning of helping people make sure people's money lasts at least as long as they do.
Yeah.
So really, we deal with kind of retirement and legacy planning, but it all started with that estate planning base.
So I'm not sure which direction to go down, because while you were talking, I had this one thought, but then when you brought up the elder care portion,
Sure.
That's what you were advertising around when, I want to say like when I found you, but really you hooked me, because there were parts of your legitimately, like, I feel silly sharing this, but there was this ad that you had on WHMI that, like, I don't know if there was an event in my life or I was at the beginning of my midlife crisis, because I was seriously, for the first time ever in my life, thinking about what happens to my family when I die. Not if, when.
Right.
And I had nothing in place. And people say, so this is actually maybe a segue to one of the topics, because I talked to a couple of people that I know, like, and trust about what do you want to know? If I'm bringing this guy, and to me, you're kind of a heavy hitter, but what do you want to know? And the first thing everybody wants to know is probate. And I will tell you, prior to sitting down with you and building my trust, the word probate is just like, well, we have to go through probate. What the hell does that mean?
Sure. Yeah. So probate, it's a court process. And really, we see two versions of probate. Most people are familiar with probate upon death, and they want to avoid it because it's a court process, it's time consuming, and it's costly.
But what is it?
Well, it's a way to transfer assets upon death, and it's part of the estate.
But what if I have a will?
Well, that's where these are different tools to try to avoid probate. And so when someone passes away, there's only 4 ways assets can transfer.
Oh,
Take some notes. There
I'm
you go.
taking notes.
So there's only 4 ways that assets can transfer. First would be through joint ownership. And I'm sure you see this with real estate, husband and wife, they're married, one spouse passes away, the survivor's in charge. Sometimes you see people name like their kids join on stuff. That's a huge mistake for a variety of reasons, and we can get into that.
We are going to definitely circle back to that.
Yeah. The second way that assets can transfer upon death is through beneficiary designations. So a beneficiary designation on life insurance or a 401k. And in fact, we can do beneficiary designations on real estate, and this is called a Ladybird Deed, which is something else we might want to touch upon.
Also in my notes.
Exactly. The third way that assets can transfer is through a trust. assets. And that's the way that a lot of people go, and there's different types of trusts. There's basic revocable trusts that avoid probate and control the distribution. And then we have asset protection trusts that can avoid probate, control the distribution, but protect your assets from creditors or the devastating cost of long-term care. But if an asset doesn't pass through one of those first three ways, then it ends up going into probate. And so what probate is a court process where if you haven't handled your affairs properly, now the court has to step in and you have the judge or the probate desk directing where your assets go. And the one thing I didn't mention is a will. A lot of people assume that a will avoids probate, but it does not.
Yes.
What the will does is gives instructions to the probate court on how to distribute the assets. So you still have to go through, at minimum, by statute of Michigan, a 5-month court process. And it's costly. 3 to 5% of any assets going through probate typically get eaten up in fees, whether it's inventory fees, filing fees, publication fees, or sometimes attorney fees. And then also it's public. So anyone can see if little Johnny is getting the house or getting $300,000, everyone's going to know that little Johnny is getting this money.
Oh, I could be a predatory something.
Exactly.
And track those court records and go, hey, little Johnny.
Exactly. Yeah. In best case, all you get is a bunch of solicitations in the mail. But worst case, yeah, there's been situations where people go through the court records and try to take advantage of certain people. Yeah. So that's why everyone wants to try to avoid probate upon death. And there's only 3 ways to do that. It's either through joint ownership, and there's problems with that if you're not a married couple, for anyone other than married couples.
I feel like, yeah, maybe we can walk through each one slowly, the pros and cons, if you don't mind.
Sure.
The little Johnny thing you were talking, the will. Mm-hmm. I didn't know this until very late in my career. And of course it was related to some real estate education I was getting, but I tell my clients, and correct me if I'm wrong, a will is nothing more than like if you were to write a letter that says, I wish that this is what happens after I die. Mm-hmm. Not unenforceable, doesn't transfer ownership of anything. Mm-hmm. It's no different than a fucking little letter you wrote that somebody found after you're dead, yeah?
Well, yeah, the will typically doesn't apply because it only affects assets that go through probate. And I had this actually in my own family situation, and maybe this was like a little seed or kernel that was in my subconscious of why I wanted to get in this area of law. I was the only child, but I had 3 cousins that were all boys from my uncle, and they're all older than me, but they're almost like big brothers to me. And I spent a lot of time with them, and some of them actually lived with us for a couple of years because my uncle, kind of sad story, but he worked for Ford. He ended up hurting his back, got hooked on painkillers, and actually overdosed when he was about 45. Wow. And he didn't have much. He was on disability. But he had these 3 sons, and he had a will, and I kind of learned this later. I was 12 when he passed away, I think. He had a will that said everything split up evenly between his 3 sons, right? Which makes sense. He loves his kids. Everything split up 3 ways, okay? So you have the will, but then he had a life insurance policy for $10,000. And this is literally all he had. Uh-huh. He didn't have a house. He was renting, low income. But the life insurance policy, the beneficiary designation said it went to the youngest son.
Oh.
And so now we have a will that says it goes to the 3 kids, and the beneficiary designation says it goes to the youngest son. Well, guess what? The will only controls what's in probate. And because he had a beneficiary of the youngest son, the will didn't control. So like you said, it's not worth the paper it was printed on. And I remember when I was 12, we were at my grandfather's, and they were arguing about it. And they had to go outside because they were yelling and screaming at each other. And now 30 years later, they still don't talk over a $10,000 life insurance policy. So that's where the will, you're right. It's unless the assets end up in probate, it does not control. And that's one of the biggest myths people have.
Yeah, absolutely. Well, this is a huge gap in a public education that I got. Mm-hmm. I didn't know any of this stuff until, not too late, thankfully, but I watched a similar situation unfold in my family. My uncle passed away. Mm-hmm. And I see this in so many you know what? I think that was probably the trigger that had me call you, really, because I watched my family devolve. It just started to deconstruct, and people are picking sides. And I've watched families fight over this fucking pen. Mm-hmm. I want that pen. Dad said that I should have that. It was Dad's favorite pen, and now nobody talks because of a pen.
Right.
Your people are fighting over $10,000 split 3 ways, $3,000. Relationship severed.
Yeah.
Crazy.
And that's what we talk about planning a legacy. It's not about always leaving a big chunk of change, but now my uncle's legacy is that because he didn't plan well, like the family's broken up over it.
Yeah.
Yeah.
So that psychology education has got to come into play for these conversations.
Mm-hmm. Yep. Yeah. So the will, like we said, does not avoid probate. It only controls where assets go if they end up in probate.
Is there a situation where you could have a will and the judge says, no, I'm not going to do that?
Well, yeah, at the end of the day, whenever you get into court, it's going to be the judge that decides things.
So you could say, my will leaves my house to my oldest child, and then the judge has all of the probate, all of the assets of the estate, and says, well, sorry, ding dong, you owed too much money. We're selling that house to pay this creditor. I'm making this up. Is that a thing?
No, you're right in the sense that before there's any distributions, when things end up going into probate, all the final expenses have to be taken care of.
Yeah.
So typically it's not going to work exactly that way. If the will says the house goes here, then typically the house is going to go there. But yeah, whenever you get into court, it can be a coin flip. And so that's another reason why we're trying to avoid the whole probate process. Yeah. And that's really what estate planning is doing. Is probate is the government's rule book. Creating your own estate plan is creating your own rule book. And we create a rule book for what happens when you pass away. That's typically the trust. And then also what happens if you don't pass away and you're incapacitated. That's the financial and medical powers of attorney to avoid the living probates, which you might see even in the real estate world where you have someone's trying to sell a house for mom who has dementia. And yes. if mom never did a power of attorney, they have to go to court to get approval from the judge to be able to sell the house. But if you've created that financial power of attorney, that's your rule book, so you can cut the probate judges out while alive. So that's why we're talking about the dual probates of not only probate when you pass away, which most people are familiar with, yes. but also probate while you're alive, which could be the guardianships and conservatorships. Yes. And that's why we create our rule book, which is the estate plan.
So let's go. Can we walk through the 4 ways?
Sure.
Starting with joint ownership, because I run into this a lot. And so what does that mean, joint ownership?
Sure. Yeah. So joint ownership is great for a married couple, where if one spouse passes away, it goes to the survivor. But we typically don't recommend naming anyone else joint on your assets, especially your real estate. And sometimes people do that as a probate avoidance tool. Yeah, it avoids probate, but by naming, say, a child joint to a piece of real estate, you're opening yourself up to all the potential liabilities of that person.
Yes.
If they were to get a divorce, a creditor action, bankruptcy, and I've even seen this in my practice where a daughter needed long-term care in a nursing home before mom did. And now, because mom added her daughter joint to her house to avoid probate, daughter's not going to be able to qualify for Medicaid unless mom potentially sells her house.
Yeah.
So joint ownership is great for a married couple, but I wouldn't recommend naming anyone else joint on your assets because you're opening yourself up to all the liabilities.
Well, let's also talk about, I just covered this in a title class that I was in with Carol Bullion. I don't know if you know who she is, but Liberty Title, I have to give her a shout out because she's just so smart about understanding curveballs like this. People like to quit claim joint owner, one of their children into joint ownership on their property, on their real estate, and that child is a minor child. So can a minor child sell property? If mom dies.
Yeah. So that would be, again, a situation of another living probate because if someone's under the age 18, legally they're a minor and they can't make those decisions. So someone would have to be appointed a guardian or conservator.
Creates a whole new layer of different problems.
Yeah. And there's different types of joint ownership too, which some people don't realize.
Yes.
So most people think joint ownership, well, if I pass away, it just goes to the other person. Well, with married couples, that's the way it's assumed, where you don't have to write anything else. You can just say Jim and Jane Smith and it goes to the survivor. And technically that's called tenancy by the entireties, which is only available to married couples in Michigan. And then we have joint ownership with right of survivorship. That's what most people think when they think joint owner, where it just, you could have 4 people listed and the survivor of the 4 of them is the one that walks away with the property. They get 100% of the property.
Yes.
Then there's also tenants in common. And what tenants in common says is if there's 4 people and one of them passes away, it doesn't go to the remaining 3, but instead it goes to that person's estate.
Correct.
Which now means it's going through probate. So
unless you have a proper vehicle set up.
Exactly. Like a trust or something else in place, Ladybird Deed, whatever it may be.
Yes.
But yeah, so joint ownership can be sticky, but as a general rule, it's good for married couples, but I would always recommend naming someone else or not naming anyone else other than a married couple on joint ownership. There's almost always a better way to handle things.
So, and I just had a thought on this. So we live in a time and in our state, dower rights are gone and courtesy rights are gone. It's not really a thing. And that would be like, go Google it if you don't know what that is. It applies to married couples.
Right.
The reason I'm bringing it up is I today often have conversations with clients about not having the other party on title, because we see a lot of situations where it makes sense for only one half of the couple to be on the mortgage.
Mm-hmm. Well, that does bring up a good point, is sometimes people confuse who's on the mortgage versus ownership.
Oh, yeah.
And it doesn't have to be the same
No.
thing. And what happens when someone passes away with a mortgage is typically they're going to trigger a due on sale clause.
Yes.
And so the mortgage company wants to be paid off before the real estate can go anywhere else.
Aren't there situations where as long as the mortgage continues to get paid,
Well,
people get away with that all the time?
So there's kind of the legal rules, which that's automatically going to trigger the due on sale clause. But especially when 2008 happened and everyone was foreclosing on everything, the mortgage company was just happy to get money. So real world, typically what would happen, as long as you keep paying the mortgage, they don't really care.
They really don't.
Yeah.
So is there really an advantage to having joint ownership of a piece of real estate? Really?
Well, the advantage is for married couples, they have a state of Michigan has given them some special privileges, and that's what's that tenancy, the entireties is. And typically with a married couple, you want it to transfer to the spouse anyways. So that is natural. But also the state of Michigan has said with tenancy by the entireties, if one spouse were to get sued for something, the home is protected if it's joint for a married couple.
I see.
So there's a certain level of asset protection that's available to married couples if they own it as a married couple.
I see.
Now, the interesting thing, just getting in the weeds a little bit, but if you were to take that joint ownership for a married couple and transfer it to a revocable living trust, you destroy the asset protection that state of Michigan has had. So if you're a married couple, typically we don't recommend the home to be owned by your revocable living trust.
But different for an irrevocable. Is it irrevocable or irrevocable?
Yeah.
Which is it?
It's irrevocable.
Okay.
And having done this, like I had to learn how to pronounce it correctly.
Yeah.
Like it's hard for me to say irrevocable. So, cause I had to like beat it into my dumb head to say it properly, since I'm supposed to know this stuff. But yeah, there's forms of irrevocable trust. Like we have what we call our castle trust, where we can move assets into the trust, and that does build in asset protection. That's different than the everyday revocable living trust that we see a lot of times. A revocable living trust offers you zero asset protection while you're alive and well.
So
it actually can destroy the asset protection available to married couples.
do you want to just roll right into that's number 3 on your list? And I'm dying to know the difference, because I for sure have an irrevocable trust.
Sure. Yep.
And everywhere I go with that, people are like, what? Yeah. You have a what?
Right.
We can't touch that. We can't. I don't know. We need to, like, people are confused.
Yeah. So, so first way to avoid probate is joint ownership. Second is beneficiary designations. Third is trust. And there's 2 main types of trust. You can have a revocable living trust that avoids probate, controls the distribution upon death. That's great. But then also we can have irrevocable trusts. And there's a whole ton of different types of irrevocable and revocable
But
trusts.
slow down and back up.
Sure.
What makes a trust revocable? If I have, it means I can take it back. It's like pretend, like I'm dipping a toe.
Yeah. Easy way to think of a revocable trust is think of it like a suitcase. You put stuff into the suitcase. You're holding onto the suitcase. You can take stuff out of the suitcase. You can change the suitcase. You can amend it.
This is my carry-on. This is my carry-on.
Exactly. Now, those are, I would say, more common, but then also there's what's called irrevocable trusts. And there's lots of different types of irrevocable trust.
Is that my check bag? Like I built it and then I sent it off to be put somewhere in the plane. I can't unpack it anymore.
Well, you can. That's the thing.
I can.
With irrevocable trusts, they can be set up differently. So the way we used to do it when we were concerned about estate taxes way back in the day, we had to you had to give up control with that irrevocable trust, because otherwise the government would say it's included in your estate for tax purposes. So to use a technical term, we used to use what's called non-grantor trusts, meaning you had to get a separate tax ID number.
You're speaking. We have a rule on the show: no speaking other languages. We're going to back up again.
Okay. All right.
Let's go back to. Can we one at a time it?
Sure.
So what if we're just talking about a revocable trust, and are you saying revocable living trust? So it's always living trust. It doesn't survive after I die.
It does survive after you die. You set it up while you're alive.
And what is the perceived benefit of that entity?
Sure. What a revocable living trust does is avoids probate.
It does, for sure.
Assuming it's funded properly. Because a trust, it's like a suitcase. By itself, it's an empty suitcase.
Yeah.
So a big problem we see with real estate is people forget to handle or fund or deed the property to the trust.
Yes, I see this too.
In fact, I sat down with a gentleman this morning talking about his mom, who's 89 and starting to get some dementia. She did a trust in 2015, but it was never funded, meaning the real estate, the farm, which is very important for the family to protect, was never titled to the trust.
Yes.
And now if she were to pass away, that farm would end up going through probate. And then B, and this is kind of getting down, but if she were to need nursing home care, the state of Michigan can actually place a lien on the farm if she were to need long-term care in the future.
It's considered her asset.
Right.
And this kind of points right into this asset protection or irrevocable trust.
Yep. Yeah.
So let's talk about that.
Yep. So the revocable trust avoids probate and controls the distribution upon death, assuming it's funded. Irrevocable trust, there's lots of different types of it, but the main type that we use in our office, we call it a castle trust. But it's a type of trust where you're still in control. You're the trustee. You're holding onto the suitcase. You can sell your house if you want to, buy another house, downsize, go from Google stock to Apple stock. You can make changes to the trust. So even though it's irrevocable, you can still make changes to the trust. Now, that's not true of all irrevocable trusts, but it's the type of trust that we're typically doing these days. And you can even get the assets out of the irrevocable trust. That's not true for all irrevocable trusts, but for our castle trust that builds in asset protection, it doesn't protect against estate taxes. So if you have more than $12 million, which is where you get taxed when you pass away.
I'm working on it.
Aren't we all? Yeah. If you have less than $12 million, you don't have to worry about estate taxes. So we're not talking about estate taxes when we're talking about the castle trust, our form of the irrevocable trust. So you pay taxes the same way you normally do. You still use your social security number. You're the trustee. You're in charge. But what it does that the revocable trust does not is it builds in asset protection. So if you were to be sued, whatever's in the trust would be protected. If you were to need long-term care in the future, say a nursing home that's running $10,000 to $15,000 a month, whatever's in the trust is protected from that nursing home or Medicaid spend down.
And that would protect my assets if I got sued, or what if my company was in my trust? Can my trust get sued, or just my company?
Well, it depends on what the issue is, but if you're operating as a business and you have like a LLC, a limited liability company, or some type of corporate structure, and you do something stupid with the business, they're limited to whatever's inside of the business. Okay. What the asset protection trust does is if, let's say you drive out of here and you hit a school bus full of kids, you do something stupid. It wasn't your business.
Yeah.
If it's in the trust, it's protected.
Okay.
Or let's say you're single, you set up the asset protection trust, you get married, and then you get divorced. Whatever's in the asset protection trust would be protected from that divorce.
Okay.
So it's like a prenup.
Yeah.
Yeah.
A baked in prenup.
Yep.
Like I already have my suitcase and this stays my suitcase.
Yep. Yeah.
So is this something you invented?
No, I didn't invent it. We just don't like using the word irrevocable because people have certain names and connotations, and
it makes it sound so final. Makes it like what seems, you know what it is? I can tell you for myself, like you didn't use that language when we met, thank God, because it makes me think like, well, I know for sure at my age that what seems like a good idea today, I may regret in 10 years.
Right, exactly. Yeah, so I never use the word irrevocable when I'm talking to clients unless they bring it up. Why is it called that? Like, is it irrevocable? I can't undo it? Not true. I can unfund it, but the trust still lives on forever? Something like that? Yeah, it's just how we get things out of the trust and how we make changes is a little bit different than a revocable trust. Okay. Like, I don't want to get too much in the legalese because then everyone's eyes are going to start glazing over.
Somebody out there cares about this. I'm sure of it.
Okay, well, here you go. We make changes through what's called power of appointment versus revoking it or amending it. So even though it's irrevocable trust, we can still make all the changes we need. It's just instead of going through, say, an amendment and revoking it, we would go through powers of appointment.
Okay. And so instead of saying, okay, I'm going to do this, let's say I'm pretty sure I gave my daughter some power in my trust. Mm-hmm. She has permission to do something. Mm-hmm. So in a revocable situation, I could say, you know what, Thea, you're on my shit list. I'm taking that away. Mm-hmm. And in an irrevocable situation, I would have to be more like, all right, Thea, you're on my shit list. I have to reassign your power. Something like that?
Yeah, basically, either a client calls us up and says, "Hey, I want to disinherit little Johnny because he's a poo-poo head," right?
Yes, that's a technical legal term.
Yeah, exactly.
That's what I thought.
And we either do it through an amendment or we do it through power of appointment. Either way, we can make the change. So that's why I don't like the word irrevocable.
It's totally a technicality. This is
Right.
literally a technicality around a legal term.
Right.
That's it.
Yeah. And there's lots of different types of irrevocable trust. And no, I didn't create this. I didn't invent this. I just put a name to it. We call it our castle trust. But what happened is that estate tax exemption that's at $12 million, it used to be at $600,000.
Oh, wow.
So if you had a life insurance policy and a house and you passed away, government could take 45% of your assets for the estate tax. So we would use a lot of complicated irrevocable trusts where you had to give up control to protect against estate taxes. But then the estate tax exemption kept going up from $600,000 to $1 million to $1.5 million to $3.5 million to $5 million to 10 to now 12 to now 24 for a married couple.
When did that become the number?
Yeah, this was really through the 2000s.
Okay.
Like 2010, we had zero estate tax, and there's actually 4 billionaires that passed away, including George Steinbrenner, owner of the Yankees that year, and there was zero estate tax. But then 2011, it came back down to $1 million, and then they made a change, and they bumped it up to 3.5, then 5.
Always a moving target.
So we used to do a lot of complicated trusts addressing that, but then the estate tax exemption just kept growing and it became less a concern for our clients. And what became more of a concern was not the estate taxes, but now my mom broke her hip, is going to a nursing home. What can we do to try to protect our assets? So attorneys prior to me, really since the 1990s, started reworking these trusts not to protect against estate taxes, but to protect against long-term care costs and lawsuits and creditors.
And can you touch on why that's important? Because what does long-term care costs have to do with my assets, really?
Well,
if I didn't know.
For most people, a lot, because what we've found is people are living longer than ever, but still they're now needing things like long-term care, and that might be home care, assisted living, or nursing home care. And current statistics say 1 out of every 2 individuals will need nursing home care.
Sure.
1 out of 2. And 3 out of 4 will need some form of long-term care.
But why does that mean my assets need protecting? I don't understand how those are related.
Sure. Yeah. So the question is, how are you going to go about paying for that care? Like if a nursing home's running $10,000 to $15,000 a month, what can you do to pay for it? And there's only 6 ways to pay for long-term care. You can private pay, so you pay out of your own funds.
With my $12 million plus dollars.
Exactly. Yeah. And hey, that if you got $12 million, that's great. Second, you can have your kids pay. A lot of times they don't pay financially, but they pay in terms of time, where they're taking time out of their day to visit the elder law attorney. Or gentleman I met with today, he's been living with his mom for the last 5 years. Mom's 89 now with dementia.
That's what.
Right. And that's how the kids pay. Yeah. Third way is through long-term care insurance, and there's different types of that. Fourth, Medicare, but Medicare really only pays for short-term rehab. It doesn't pay for long-term care. Fifth is the veterans benefits. In the gentleman I met with today, his mom was married to a veteran, and we talked about bringing in extra $1,000 to $2,000 a month to pay for care. But 6 is Medicaid. Medicaid will pay for that nursing home care, but Medicaid has an asset test where if you're a married couple with more than $120,000, you're not going to qualify. And then Medicaid looks back 5 years to see if you moved any money around, and if they have, they're going to penalize you.
So this is like you must be broke enough to get this benefit.
Right. And so this is where, through long-term care planning, one of the trusts, the Castle Trust, we can move assets into the trust. And then once we make it 5 years, 100% of what's in the trust is protected from that nursing home or Medicaid spend down. So now you can have Medicaid pay the base level care, and then you have a pot of resources to pay for additional services to improve quality of life. Or if we're a married couple, if one spouse needs long-term care, the healthy spouse isn't completely impoverished.
Yeah.
It's no different than the planning we would do if you had a child with special needs like autism or something like that.
Which I also have inside of my trust.
Yeah.
Is a trust in a trust.
Right.
It's like the Inception Trust. I think you should call it that. Run with that. Marketing.
Yes, I like it. But yeah, it's a similar concept of, hey, if I have someone I love, whether it's myself or a spouse or a child, I want to make sure they have every benefit available. And so if there's a way to set it up so that we can have governmental benefits pay that base level care, and then a pot of resources to pay for additional services to improve quality of life, that's why most families do this type of planning. And really, that's what it comes down to, is we're just helping good families plan, protect, and preserve what's important to them.
Yeah.
And protecting against long-term care costs is one of the bigger issues these days.
And you said that the ways to pay, there were 6, right?
Yep,
Not 7.
Yeah. So there's 6 ways. We can either private pay, just pay out of our $12 million if you have it.
Which won't last as long as you think, because $12 million doesn't sound like much these days. I can't believe those words just came out of my mouth.
Yeah. Second, the kids pay, and we don't want to rely on that. Third, long-term care insurance. That's something you have to set up ahead of time. Fourth, Medicare, which pays for short-term rehab. Fifth is the VA benefit. And then 6 is Medicaid.
And VA only applies if you are
a veteran or surviving spouse, and you have to meet certain requirements. And even that has an asset test of $120,000.
Oh, really?
Yeah.
I did.
Yeah.
So you've got, it's like roadblocks and.
Mm-hmm. Right. And that's where the types of trusts we can set up, we're not trying to protect against estate taxes as much these days, but protecting against these long-term care costs to make sure that you can get the best quality of care possible.
Yeah. It's almost like unanticipated, but they're actually anticipated future needs. Maybe that people hope that they won't need, but they probably will.
Right, yeah. And that's, I kind of joke around and I tell people I deal with like death, taxes, and incapacity. Like no one likes to think about this stuff. We deal with death and taxes and incapacity. And it sounds dark, but it's stuff that has to be done.
Yeah.
And most people, they want to put their head in the sand and pretend it won't ever happen. And I sit down with plenty of families, and not to sound sexist, but a lot of times it's the
stoic
old man,
like,
oh, I'm never going to need long-term care.
Yeah.
And then
That's
it's the
my
wife
dad, man.
saying, hey, like you're 2 times my size. If you fall, I can't pick you up.
Yeah.
So,
and you shouldn't have been on that ladder to begin with. I told you.
Right. Yeah. So that's been, and that's really what elder law is all about. And so I didn't start off like planning for long-term care and doing elder law. Like I planned on just doing estate planning, but I was getting calls, not that mom passed away. I was getting calls that mom broke her hip and now needed nursing home care. And how do we go about paying for it? So very quickly, I tried to learn everything I could as it relates to elder law. And in 2008, I became what's called a certified elder law attorney, CELA, which is the top designation as it relates to estate planning and elder law, where you have to be peer reviewed and then sit down and take a 6-hour exam, which is like taking another bar exam. And I think only about 15% of the attorneys end up passing it. And so there's now 17 of us in the state of Michigan.
So you're pretty elite. You are a big deal. All right.
Yeah.
No, I mean, roll with it. That's a thing worth saying. Because, for people who are going to do estate planning, I feel very lucky to have just found you in my town. Because I learned so much about how vulnerable I don't have a lot of stuff. I don't have a lot of money. Mm-hmm. It's not like I'm not here to sell your product or pitch your shit, but I'm here to tell you that I just didn't know. And if you're listening to this show right now, even with my little bit of stuff that I have, it made so much sense to organize it for my family to not have to think about it. If they want to be mad about it after I'm dead, they can be mad at me. They don't have to fight each other now. Right. It solves that problem. Yeah. To your earlier point about the brothers, right? The brother cousins.
Yeah. You're creating your rule book and you're creating the legacy that you want to leave versus leaving a mess or letting the government decide what's going to happen.
So what is the biggest mistake that you see people make? Like they come to you thinking they have it figured out and you're like, no, everybody does this thinking they're solving their problem, like the quit claiming the kid onto the title of the property. Yeah.
We have a report, we call it like the 10 gruesome estate planning mistakes.
Oh, yes. I love all these lists. Look, we've got 4 ways to transfer assets, 6 ways to pay. Yeah. And now this is the 10 what now?
10 gruesome estate planning mistakes. 10? See if I can remember them all.
This is like David Letterman top 10
list.
Yeah,
top 10. Number 1.
Yes. Do it.
Not having an estate plan. So just not having anything in place. And really, you're opening yourself up to probate while you're alive. If you get a knock in your head, you have a stroke, you have dementia, or you're opening your family up to probate upon death.
And probate is where you would go if my kids suddenly decided mom is off her rocker. And even if I'm not, they could drag me to court and be like, sorry, mom, we have all this proof. You're crazy. And the judge could.
Right.
It's a fear-based conversation. I'm just...
Yeah, exactly. So that's where guardianship comes into play, and that's a whole process in itself. And it's really an uphill battle to have someone deemed incapacitated, because this is like America. Like, we value freedom and independence. And a tough conversation I have with families sometimes is they'll come in and say, "Mom's making poor choices." I'm like, well... Mom's entitled to make poor choices.
Yes. Mom married this guy that you don't like, and she's giving him her millions.
Yeah.
Doesn't mean she's
she
crazy.
still have capacity? And they're like, yeah. Does she recognize you? Yeah. I'm like, well, Mom can do what Mom wants to do, even if you don't agree with it or you think it's not in her best interest.
And you field these phone calls, it sounds like. That's real.
Yeah. And so, your options are like, with the power of attorney, you can make decisions for Mom or Dad, but they can still make their own decisions. The only way you can actually take away someone's authority and make their decisions is going to court and getting a guardianship and conservatorship. And now the judge is going to say, okay, Mom, we're deeming you incapacitated. Like, we're almost turning you into a minor where you can't make your own choices anymore. So that's a big step. I call that the nuclear option. Like, no one wants to go get a guardianship for Mom or Dad. And then the judge will send out a guardian ad litem, someone appointed by the court to interview Mom. And then Mom will have her own attorney, whether court appointed or she can hire her own. And it's litigation of A, to see if Mom has capacity. And then B, let's say she doesn't. It's no guarantee that they're going to appoint you as the guardian. They might appoint another attorney that has 250 other wards of the state.
So my daughter, after she turned 18, I had to make a appointment for her to have a physical to go to camp. And I called to make the appointment, and the doctor was like, "Sorry, she's not a minor. You can't do that." And I was like, holy shit.
Right. And
I had to cross that bridge. I mean, it was...
Right.
And they did. Anybody who talks to my daughter knows this is the right thing to do, but we had to...
Right.
She got assigned her own attorney. We had to be privately... her father and I had to be privately interviewed. We had to go before the judge, like all the things.
Yeah. And that brings up a good point. If you have adult age children, what you should do is have them sign a financial and medical power of attorney appointing you as the parent to be able to make those decisions. Because once someone turns 18, legally they're an adult. Like, if you were trying to get medical records, and I've had this happen, a colleague of mine, his daughter was over at Grand Valley, was injured in an accident, and he was trying to get information, and she didn't sign any HIPAA. She was over the age 18. She was an adult, and the doctors wouldn't talk to him.
And they can't.
Right.
They have to protect themselves.
Right. Yeah. Especially with the HIPAA authorization, the release of medical information. So that's one of the things we recommend is whenever you have like 18 to 25-year-olds, adult children who aren't married, have them or put together a financial and medical power of attorney. Like, the kids don't care. Like, when you're 18 or 25, like, you think nothing bad's going to happen. But it's the parents a lot of times grabbing them by the ear and like, "Hey, sign this stuff."
Yeah, that's a good piece of advice right there, because I have nothing for my other two.
Right. Yeah. And it's real quick and easy. It's not a full comprehensive estate plan. All they need is what we call the disability documents, the financial and medical power of attorney. So that's kind of mistake number one, is just not having anything at all.
Well, and they had told me, I don't remember who told me this, but someone was like, "Listen, Rachel, your daughter is not a minor," to the point where if she wandered off and you didn't hear from her for 3 or 4 days, there's not really anything we can do to help you, because you're not in a position to make anything happen.
Yeah.
And that brought it home for me.
Yeah. A lot of people assume because they're married or they're a parent, they have the authority to make these decisions. We see this with married couples too, where they think, "Oh, I don't need anything to make decisions for my spouse." Well, understand, like, especially with medical powers of attorney, there's an old case, this woman named Terry Schiavo. She was down in Florida.
I remember this.
Yeah.
Her husband and her parents were fighting.
Exactly. Yeah. She was in a vegetative state, and her husband wanted to remove her from life support. And you'd think, as a married couple, okay, that's automatic. It's not. She didn't have a medical power of attorney, and her family wanted her to remain on life support, and it became a big court battle that lasted over 8 years. All of this could have been avoided had Terry Schiavo had that medical power of attorney. And there's two big takeaways. First of all, just because you're married doesn't automatically give you the authority to make these decisions for a spouse, just like for an adult age child. And the second key takeaway is, how old was Terry Schiavo? She was in her mid-20s when this happened. So a lot of people think estate planning is just like for old people. Understand, you never know when life's going to throw you a curveball. So that's why we think it's important to have that rule book in place.
Yeah, that's I'm going to chime in with this too, something that I don't know why this one's so hard for me to get through my head, but I always thought estate planning was something you do and then you put it away because it's done. But it's really a living thing that changes as your life evolves. Like it's, you and I are supposed to visit once a year. Often I avoid that meeting, but
again, it's death, taxes, incapacity. Right. It's not a fun conversation.
Makes some squirming happen.
But yeah, you're right. Estate planning, it's not a one and done type proposition. This is creating your parachute. You never know when you're going to need the parachute, but you want to make sure there's no holes in it. And one of the biggest things we see, especially in the real estate world, is buying a cottage up north or buying or selling your house and not thinking to fund it or title it in the name of the trust.
Yeah.
That's one of the questions we ask in our annual reviews with clients. Did you purchase any new real estate? And a lot of people don't think that, okay, I did my estate plan, it's done. But, I bought a cottage up north. I bought a lot, or we bought a lot to go hunting up north. And they don't think to put it into the trust or put it as part of their estate plan.
So now it's not protected from probate. It's also not protected from a Medicare look back or Medicaid. Yeah, Medicaid.
Yep.
Sorry. I do that all the time.
You're good.
All right.
Yep.
Number 2.
Yeah. So mistake number 2 is having what I call it just a basic I love you will. So a lot of times, I downloaded a will or my family attorney put together a will. I'm all set. Okay. Well, we already talked about, does a will control everything? No. A will is your ticket to the probate court. If you want to avoid probate, you don't want to rely on a will.
I got a ticket to probate. Yay.
Yay. That's not a ticket you want. Third mistake is owning property jointly. So without anyone other than a spouse. And we already kind of talked about why this is a bad idea. You're opening yourself up to all the liabilities of the people. And also there's just better ways to handle it. There's always a better way to handle other than joint ownership, whether it's through beneficiary designations or powers of attorney or Ladybird Deeds. It's always a better way to handle things. Fourth mistake is, what was the fourth mistake? Not reviewing your estate plan.
Oopsie.
Yep. So this is why we have a program with our clients. We're meeting on an annual basis to learn what's new in your world, learn what's new in the legal financial tax world, come together and see if there's any updates. Did you buy a cottage up north? Is there someone we have to disinherit? Did one of your kids turn 18 and now we should do the financial and medical power of attorney for them? So those are things that need to be reviewed. Fifth mistake is not thinking about a trust as part of your estate plan. Not everyone needs a trust. Like there's ways to avoid probate without a trust. You can rely on beneficiary designations and then with the real estate do a Ladybird Deed. All of that avoids probate. But
can we talk about Ladybird Deed on a rabbit trail right now? What is a Ladybird Deed?
Yep. So what a Ladybird Deed, it's named after Ladybird Johnson. And basically what happened is there's a law professor that wrote a book on different types of deeds and he named them after different celebrities. But what a Ladybird Deed is a type of deed that says it's in your name while you're alive and well. And then upon death, it goes to wherever the deed says it's supposed to go to. So it's like a beneficiary designation for real estate.
Okay.
So you're in control. You can sell. You can refinance it.
Is this a filed document? Like at the Register of Deeds, I could have a Ladybird Deed that says, Thea's already been mentioned. Thea gets my house.
Sure. Yep, exactly. So what this is an answer to some people do what's called the deed in the drawer trick or do a quitclaim deed that's never recorded.
Yes.
Yeah, that's in
Terrible.
the real estate world. That's one of the things we see a lot, and it's not a good way to do it.
No. Say that again. It's a terrible way to do it.
Terrible. And so what people are doing, so the quitclaim deed or the deed in the drawer trick, what they would do is they would sign a deed giving the property to like the kids, but they would never record it.
No.
They would either keep it in the estate plan
safe.
or the attorney would hold it in a drawer.
To be filed upon death.
Exactly. Yeah. So there's a couple inherent problems with this. First of all, when you sign that deed, technically that's the transfer, even if it wasn't recorded.
Yes.
So that can be scary from a liability standpoint of, okay, if someone finds out about this and then little Johnny got a divorce or little Johnny got in a car accident, mom might lose their house. Okay. Second, that deed has been lost before. Like if you lose that deed, guess what? The home's going into probate and now it's a mess. Third is that when you sign that deed, technically what's supposed to happen is you're supposed to notify the property or the city and file a property transfer affidavit.
Yes.
And if you don't, that's going to piss them off and they can assess fees and fines for that.
Oh, I didn't know that.
Yeah.
That could also impact your principal residence exemption, I imagine, if somebody got mad enough.
Yeah. So the deed in the drawer trick not a big fan. Terrible, as you said,
Yep.
right? So what should you do? And I already mentioned you probably should not record the deed directly to the revocable trust if you're a married couple, because you're destroying the tenancy by the entireties. And also, if you put it in that revocable trust, it's a countable asset for Medicaid if you're to need nursing home care in the future. So we don't deed it directly to the revocable trust. Asset protection trust, yes, but not the revocable trust. So that's where the Ladybird Deed comes into play, which is, it's like having your cake and eat it too. There's no downside to doing a Ladybird Deed. So what the Ladybird Deed is, again, it's in your name. You can refinance. You can do whatever you want. You can sell it if you want.
It's kind of like, makes me think of like a, what is it called? Is it a life estate? No.
Yeah, technically what it is, it's called an enhanced life estate.
Okay.
But I try not to use big legal words like that. I don't want
my like real estate 101 training licensing class
Yes.
is like starting to wake up in my brain.
Yeah, we can talk about fee simple and
No,
okay, all right.
no, I'm not a title agent.
All right. Yeah, so technically it's an enhanced life estate deed.
Okay.
But most people know it as a Ladybird Deed.
Yes.
And really the easiest way to think about it is it's just a beneficiary designation for the home.
And I can have that. I don't have that, but if I had the deed to my property in my personal name and I said it goes to Thea when I die, and then Thea gets on my shit list, I can file another one that said, nope, now it goes to Nash when I die.
Yep. Yeah. And the nice thing about it is it's recorded at the county. Like you don't have to even hold on to your paper one when you get it because it's already recorded at the county.
Publicly available for the title agent when they do the
We notify
search.
the city with a property transfer affidavit, so it's all up and up. So it's doing the same thing as that deed in the drawer trick without any of the downsides.
Yeah.
There's like no downside. And so it transfers, it avoids probate, it avoids estate recovery. If you were to need Medicaid, it's a perfect transfer vehicle.
It's like the real way to do the thing you're trying to do with this weird drawer trick.
Yeah, where you're opening yourself up to all the things that could go wrong. I'm not saying they will, but I've seen it go wrong enough to say, why risk it?
Well, these are the things that 95% of the time probably don't go wrong, but when they do, it's the biggest deal of your life.
Yeah.
So why would you even expose yourself to that kind of risk?
Especially with what for many people is their biggest asset. Why
Yes.
would you try to shortcut proper planning with what could be your biggest and most important asset?
You know, it's like $3 to file a deed or 30 or something. I mean, you're saving $30.
Right. Yeah. Yeah. Exactly.
Yeah. All right. So we were on not thinking about a trust as an option. That's number 5.
Sure. I'm missing it.
I know.
Yeah. Another issue is just thinking about what happens when you pass away versus what happens if you don't pass away.
Oh, yes.
So estate planning, it's not just about death. It's also about planning for life. And so it's more than just a will and a trust. This is where having the financial power of attorney, having the medical power of attorney, thinking about planning for long-term care is important as well. So it's not just thinking about death, but it's also thinking about what happens if you don't die.
Right.
Yep.
Other non-death events.
Yep. Another big mistake, I'm not sure if I mentioned this one, not funding the trust. So I don't think I mentioned that as a mistake.
not as part of this list, but it was referenced. So, and can we talk about what that means?
Yeah. So let's say you do have a trust. The trust by itself, it's like an empty suitcase, meaning it doesn't actually control things. What has to happen is you have to title assets in the trust. And so that's changing beneficiary designations to point to your trust. That's doing real estate, either doing a Ladybird Deed that says it flows into the trust upon death, or if you have an asset protection trust, you deed that property directly to the trust.
Right.
So not funding the trust is one of the biggest issues. And that's where something that makes us a little bit different is most firms will like prepare your trust, but then just give you a letter to say, hey, go fund your trust. What we do is we actually work with our clients to make sure everything actually gets funded and titled properly.
I can attest to this. All my stuff got...
Yeah, it's
like
a pain in the butt, but it's much better to get it organized and all in the trust now versus not doing it. Now your kids or beneficiaries have to figure out where everything is located.
Yeah, absolutely. And I got a nice big fat binder out of the deal.
Exactly.
But it's all in one spot.
Right.
So side conversation about funding the trust. I have, and I'm a little bit out of my league with what I'm about to say. And okay, so I have this situation. We titled when we built my estate, and this was probably 7 years. This was a while ago. So we built this trust, we funded it. I titled my property, my principal residence from myself personally into my trust. And then I found out after the fact that impacts my title insurance coverage. So what I didn't know is what I should have also done. And I'm saying this in case you're thinking about doing this too. before you transfer ownership of your property, your real estate, contact the title insurance company that holds your owner's policy and get an addendum or a rider continuing the coverage into the new owner's name. It's a tiny little loophole and very unlikely that anyone ever needs their title insurance, but that policy, I mean, it's an insurance company, right? Their job is to try to avoid paying every claim.
Yeah. Along the same lines, we haven't ever seen this as an issue, but I could see how potentially it could be an issue, is also think about property and casualty as well.
What do you mean?
Like homeowners insurance?
Like I should call my HOA call my HOA. That's wrong.
Right. Yeah.
HOI.
Right. And we see this more with like LLCs and stuff like that. Mm-hmm. But you just want to let your homeowners insurance know as well.
So I want my policyholder to be the trust, not me personally.
Probably what they do is list both of you.
Yeah. Okay. Yep. No, see, these are, this is the things you find when you get into the weeds, and that's where I love to be.
Sure. Yep.
So insurance across the board, make sure that they know. Mm-hmm. Only because there's going to be that one underwriter who's going to be like, well, I'm sorry, but you are the insured, and the owner of the property is your trust. And that's just a technicality we can't honor.
Right. Yep.
That's what they do. Mm-hmm. Okay, that's 7. What's 8?
You know what? I can't remember the other ones. I remember the last one. The last one is understanding, or the last mistake is thinking that the enemy is probate or the IRS or long-term care costs. It's really yourself and procrastination.
Tell me more.
Well,
with your psychology degree.
Yeah. Again, like we talked about, no one likes to think about this stuff, and they always want to put it off as long as possible. So the biggest enemy is really procrastination. Too often we get calls of, hey, like when people have young kids, the first phone call is, hey, we're traveling for the first time without our kids. If the plane goes down, we want to have something in place.
Yeah.
And we're leaving next week. I'm like, okay.
Right. Well, what about the letter? I've seen notarized letters.
Exactly.
Like, if my husband and I die, our child shall go to so-and-so.
Yeah.
Is there any legal backing to my little notarized letter?
What would happen is it ends up going to court, and that would be entered as evidence. And
okay. Then the court decides.
And now it's up to the judge. So, but yeah, procrastination. That's something that we always hear is like, oh, I meant to do this last year or years ago. And like, when's the perfect time to do this? Like right before you need it. But you never know when life's going to throw you a curveball. Like Terry Shiloh didn't expect to be in a vegetative state when she was 25, right? So that's the biggest thing, is just get up and do it.
So is there a negative effect to over planning? And I will tell you where that question comes from. I listened to an NPR broadcast like 18 months ago, maybe, that was talking about like foundation grant money that has so much strings to it that, you know, like somebody's going to bequeath some kind of forever giving fundage towards something that they love. And I wish I could remember the broadcast, because they specifically talk about this boys' school that somebody started to try and save these boys. I'm probably bastardizing the hell out of this, but it had so many hoops and rules that are nearly impossible to apply today.
Right.
And like one of them was you had to have $100 bouquet of a specific type of flower. Like, do you see that shit in stuff in a I see it. I see over complication in two ways. And I view my job as taking all this complex legally stuff and trying to make it as simple and easy and straightforward to understand as possible. Like, I don't want over complication. So I see it in two ways. One, I had a gentleman come into our office who wanted to hire us for estate planning, listen to like our radio show and stuff. And so he felt like he knew me, and he was an attorney himself, not doing estate planning, but he had like attorneys are the worst clients. I'm just going to say
them and engineers. Like I have to basically take them all to law school. If I know I have a majority of my clients are engineers, not to stereotype, but a lot of times it's like an engineer and a teacher, engineer and a nurse. That's the majority of our clients.
I like that you say you have to take them all to law school, because I have to drag them through all of the nuances of what could happen in their real estate deal.
We kind of joke about like, all right, well, we got to add a half hour to this meeting. And a lot of times it's true, just because we have to go through they got to like open up the engine and kind of see how it works. And I make the analogy to like a doctor, like, let me do my thing. Like, I'll diagnose whether it's a heart attack or you're having just
Yes.
like throat issues. But if we're performing heart surgery, I don't need to show you every little thing that we're doing.
Yeah. I got to be able to navigate
let me
it.
do my job. Yeah. And I'm not a handy guy. So like when I take my car to the dealership, like, I don't know if it's a flubberguster or something. I just want my car to run,
Yes.
So tell me what your goals are. We'll develop the strategy and let me pick the tools and we'll talk about it. But yeah, so I see... so this gentleman comes in and he has like 3 irrevocable trusts that he drafted himself.
Oh,
and he has like an LLC over here and he didn't have a lot of assets. I was like, why are you doing all this?
Yeah.
Like, what are you trying to accomplish? And he just likes the complexity of all of it. And
intentionally Byzantine and complex. So it's not easy to navigate.
So sometimes I see that.
What did you do? How do you handle 3 irrevocable trusts?
Told him we wouldn't be a good fit.
Okay. And I was going to ask you that question. Like, do you ever turn down a client? It's hard. But
and that's
it's the right
also the
thing.
nice thing about my type of law is like, I don't have to work with everyone that comes in. Like, you have to be good people. Like, you have to treat my team with respect and nice. And just like, not everyone's going to hire me. Like, we don't hire every potential client that walks in the door. First, I need to be able to help you. Some people I can't help, and I'll point them in the right direction. But rare cases, someone's like rude or just negative, and like we're at a position like we don't have to help everyone that walks through the door. Like we're helping good families plan and protect what's important to them. Or in his situation, like I didn't feel comfortable with his planning, and he didn't want us to do the planning the way we wanted, and so I was like, you know what?
Yeah.
You keep doing what you're doing. I'll give you my opinion, and then we'll part ways. But yeah, getting to your point, I try to steer people away from over complicating their estate plans, because understand that at the end of the day, someone has to administer this.
Yeah.
Like the successor trustee has to follow your instructions. And if your instructions are overly complex, that can make it really hard to administer or even impossible. And I see this also with the medical powers of attorney. Like I see sometimes people have their medical power of attorney where they have like check boxes of every single situation. And I look at that and I say, medical technology is always changing. Like if you say you don't want to be on a ventilator, but all of a sudden ventilators cure lung cancer and your legal document says you can't be on a ventilator, your hands are tied.
Yes. I have not even the same level of like gravity, but I have these conversations about real estate contracts. I'm like, you get over languaging, you are backing yourself into a corner by accident.
And I'll fully admit, when I was a younger attorney, I didn't understand this as much. And so clients would say they want this and this and this. And I'm like, okay. And like, I remember one situation where, versus now I try to steer them to more simplicity versus building in all this complexity. But I remember one situation, and I'm not saying the planning was wrong, but it was just overly complex. But this one woman, she had a bunch of kids, and they were all like derelicts. And she was the first one to admit it. She's like, you know what? Like one of them is like on drugs, the other one's in jail, and like, and so, and she had some pets. She had some cats that she loved. And so we set up a pet trust. So when she passed away, there's money set aside to take care of the pets. And then also she wanted to make sure that she wanted to give the kids like one last chance to like turn it around. And she had like $1.5 million. So she gave a big portion to the Humane Society. And then each kid was going to have the opportunity I forget exactly how much. And I should say this is a hypothetical client.
Sure. They had to earn it though, right? Like they
had to jump through these hoops
a milestone
of being drug free. They had to donate time to the Humane Society. They had to have their license restored. They had to be out of jail. And there's like 3 other things. And and we drafted the documents and stuff. But now, like looking back, I'm like, do you know how much work the trustee is going to have to do to like... And
verification becomes an issue.
Yeah.
Yes.
Yeah. So I think that's an early mistake that I've corrected as I've gotten more experience.
So how would you handle that circumstance today? If I wanted to be, for my kids who are going to inherit a bunch of debt in like $50.
Yeah, I wouldn't put as many rules and regulations. I would... Typically, my approach now is you trust the people that you appoint to serve these roles.
Yes.
So whoever you appoint as a financial or medical power of attorney, let's not put a lot of restrictions on them because we don't know what life's going to hold.
Right.
But if you trust this person, let's give them all the authority they need. Similarly with a trust, when you pass away, like I see sometimes people say, well, like with minor kids, like my kids are 9 and 11. And so I see some people initially come in and say, well, I want, if they do go to school, then I want them to get X amount of dollars. If they don't go to school, but they go to culinary school, it's this, or they can have this much for business.
Trying to like career path your child and tie it to your inheritance.
Yeah. So instead of that, what I'd like to do more is just say, you know what, who do you want to serve as the trustee? Like my kids are 9 and 11. I don't want them getting money out right now. They're going to spend it all on stuffed animals and Legos, which would be fun, but it's not the best use of the money.
Yes.
So God forbid I pass away and my wife passes away. I've appointed a trustee, someone else that I trust, hence the word trustee, to manage the money. And I'm not putting a lot of handcuffs and saying, do this, do that, because I don't know what life's going to hold.
Right. And to your earlier point about the ventilator.
Right.
And when you were talking about if they go to school or not, like the whole cultural conversation around college has shifted dramatically just in the last 10 years.
Yeah. College may be free in the future, or maybe you shouldn't go to college.
No, I mean, there's all of this resurgence about like, where are our tradespeople?
Right,
And people
exactly.
want their kids to learn how to be plumbers and
Some of my wealthiest clients are trades, plumbers.
HVAC. I wish I was an HVAC guy. That guy makes a shit ton of money off me.
Yeah. Yeah. I wish I was handy. My only tool is a pen and a checkbook. So, yep.
Okay, so dang. What else? We talked about rookie mistakes, most common mistakes.
Yeah, just especially with real estate, I think the big things are understanding what a Ladybird Deed is, because it's a great way to transfer assets. Unless you have an asset protection trust, a Ladybird Deed is almost always the way that you want to go. And it's an enhanced life estate deed, to use a technical term.
Is that something I can get drafted at closing when I'm buying my house?
Typically, no.
No.
Typically, the title company is just going to put it in your name. And so that's where you would contact an estate planning attorney to draw up the Ladybird Deed. So
follow-up question.
Yep.
How do I find, attorneys are like realtors, kind of a dime a dozen. Most of you suck. So how do I find somebody who knows what they're doing? This sounds like a lot of like a complicated navigation.
Yep. So the best way to find someone is to Google Chris Berry, estate planning.
Love it. No, that's the answer I was looking for.
No, but because I can only work legally with clients in Michigan, I'm not taking any other bar exams, but when they ask like, how should I find an attorney? And it's hard to like judge attorneys. It's hard to judge realtors versus like buying this table. Like I can feel this table. I can touch it. Like it feels sturdy. It looks good. But buying legal services, it's kind of hard to like, what's a good one versus a bad? So that's where that CELA designation, certified elder law attorney designation, that this person has been vetted. So if someone asks me for, how do I find an estate planning attorney in Ohio? If I don't know one, I'm going to recommend that they go and find a certified elder law attorney. And there's a website called NELF.org, National Elder Law Foundation.org, and that's where you can find CELAs in your area.
Is this a sanctioning body?
It's through the American Bar Association.
Okay.
So it's really the gold standard as it relates to estate planning and elder law. Because you're right, there's a lot of crappy attorneys out there. Not all attorneys are created equal. Like gentleman who came in today, he had a 1-page financial power of attorney, a 1-page medical power of attorney, and he had a will that said everything should go to 4 people, and a trust that said the same thing, but the trust wasn't funded. The financial power of attorney was missing some key language, and it was drafted by an attorney.
Yeah.
So there's good attorneys and bad attorneys.
Yeah.
Just like there's good doctors and bad doctors. But this CELA designation is a way to tell that, hey, at least this person has the necessary experience, has been peer reviewed, and was able to take a 6-hour exam and pass a test on estate planning and elder law.
So there's your baseline, and then you start interviewing people for, are they a good fit for you?
Right.
Absolutely.
Yeah. Yep. Yeah. So first thing, understand what a Ladybird Deed is. Second thing, understand probate and how to avoid probate. And then something else that comes up is when we're dealing with real estate and trusts, we have to have a certificate of trust.
Yes.
A certificate of trust.
Yes.
Yep. So what a certificate of trust is let's say you set up a Ladybird Deed, you pass away, the Ladybird Deed says it goes to the trust, it appoints a successor trustee who's now in charge of selling it to distribute it to the 3 beneficiaries. So the Ladybird Deed, when you record the Ladybird Deed at the county, okay? But now you've passed away. Now your successor trustee needs something to give him or her legal authority to be able to work with the realtor to sell the house.
Yes, and the title company is going to want to see this,
Right.
that you have the authority to be doing what you're
So
doing.
you could give them the full trust, but that's a private document and probably 50 to 60 pages.
Yes.
Or you can give them what's called a certificate of trust, which says A, the name of the trust, B, who the trustee is, and C, gives the real estate authority to sell the property. So that certificate of trust, we always do initial one, but a lot of times when someone passes away, we're going to have to do a new certificate of trust saying that successor trustee is now the person who's able to act. And sometimes they want the certificate of trust done within the last 90 days, or
Yes.
they might have different restrictions.
They want
on it.
revised
Exactly.
to show that it's a current document.
Yep. So that's where people ask, well, like, do I need an attorney when someone passes away? Well, if everything's handled properly and avoids probate, you don't need an attorney to walk through the probate process, but you may need us to do that new certificate of trust that the real estate company would need.
So when I die, and I don't even remember who so there are a couple things. First, I got to say one thing that you've kind of touched on is the trust will assign people to handle things. One thing I know for sure that I like about my trust is it also assigns the next person and the next person.
Right.
So if my sister Cassandra is my medical power of attorney and she's dead by the time I die, it rolls right to my daughter Thea. And if she's dead, hopefully my dad's still alive. Yeah, it's something
Right.
like that,
Yeah.
right?
Yeah. So in all the documents, whether it's the trust, financial power of attorney, medical power of attorney, or the will, we typically name one person and then successors.
Yes.
Because we never know when life's going to throw you a curveball.
Right. And God forbid that person dies before my annual review and we forget to
Right.
swap them
Yeah.
out.
So typically we like at least two backups.
So when I die, if my person is Cassandra, which I think it is, does she have to call your law office?
No. So that's something that people need to understand is like if we
What if you're dead?
I don't plan on dying anytime soon.
Thank goodness.
But you're not locked into that estate planning attorney for the rest of your life. So if we drew up a trust for you and you decided you don't like 6'5" guys with gray hair, you could pick a different attorney.
You are kind of sketchy.
Yeah, exactly. Likewise, when someone passes away, they don't have to go back to the firm that drafted the documents. Okay, so we have situations where maybe we put together a estate plan for our clients, but then the client's parent passes away, and maybe that firm's not in existence anymore. They come to us to do the certificate of trust or help them administer the trust.
And if my trust gets burned up in a house fire, is there a copy somewhere she can go get? How do you handle that?
Yeah, so we always give our clients a hard copy of all of the documents, and then we scan everything into our system. So we keep electronic copies, and then we also give them a thumb drive, so they have PDF copies.
So for how long do you keep these electronic copies?
Our whole practice.
Yeah, just keeps it. Okay.
Yep.
And then this was a way earlier question that I forgot to ask, and I feel like I know the answer, but how much does it cost to do this?
I'm going to give you the lawyer answer of it depends.
It depends. So favorite real estate answer to everything is what? It depends.
Exactly.
Sure does.
Right. Yeah. How much does a house cost? It depends, right?
Yes.
But
having said that,
yeah,
how much do I need to basically, like, I don't know, you got a ballpark.
Sure.
Are we talking $50,000 or $500,000?
Yeah. So typically there's a range, and you're probably looking from a couple grand to 10, 15 grand on the high end. Now, if you have a loved one in a nursing home right now, and we have to do like a Medicaid crisis plan to try to protect assets and submit a 150-page Medicaid application, you're looking at potentially 2 months worth of nursing home, which could be $20,000.
Yeah.
So that's where typically what we do is we first try to figure out what are you trying to accomplish, figure out the best strategies to help you accomplish that, and then pick kind of the tools or the plans. And so for our clients, we typically give them a couple different options at a couple different price points, but you're typically looking anywhere from a couple grand to 10 grand.
So though it's not super cheap, it's not cost prohibitive, like out of reach. This is not something for the only wealthy.
No,
This is something for people who have lives. Lives.
I know. And if we're just doing like powers of attorney, then it's going to be less. Like if you have like a 19-year-old and you want to get a financial and medical power of attorney, you're looking at a couple $100.
Yeah.
But that's where like we're always trying to, it's like a doctor's office. We got to figure out what's going on, and then here's how we're going to fix that issue.
Yeah.
Yep.
Okay. And then I have a dumb question that I've meant to call your office about a dozen times easily. Because you drove home in my mind so fiercely about funding the trust that like every time I start a company, the owner of the company is the trust.
Right.
So everybody wants to know the name of the trust. And on my certificate of trust, it says, I can say it, right? There's no risk for me saying the name of my trust, or is there?
You can say whatever you want. Attorney-client privilege, I'm not going to share your information.
I know, but is there any unseen liability if I say the name of my trust? It's an entity.
No.
Okay, so it is called the Evers Trust, dated May 22nd, 2018.
I don't know.
Let's say that's it. The date portion is in there.
Right.
So when I go to title things to my trust, people put in that field, the Evers Trust, hard stop. And I'm like, I don't think that's enough because my uncle might have an Evers Trust and my sister might have an I'm not the only Evers.
Well,
can I rename my trust? I want to name it like, I don't know. I want to give it a human name.
Okay. Yeah. You can name your trust whatever you want. Like I have some people name it some silly things. Like I won't get into it, but yeah. So the name of the trust is important. The date is also important.
But the date is not part of the name because it's all in bold print.
Correct.
So I'm safe with the people who kept insisting about the Evers Trust.
Right.
They placate me.
Yeah. Well,
but then they do what they want.
Think about it. How many John Smiths are there in the world? How many Smith trusts?
Exactly.
So what happens is the trust is tied to a number, which is your Social Security number.
Okay.
Unless you've passed away or unless it's some type of complicated irrevocable trust where it'd have its own tax ID number.
Okay.
So that's really like with the different financial institutions and everything.
Yeah.
They care about the name, but in reality it's tied to
my social.
Yeah.
So even
I wouldn't recommend you telling everyone your Social Security number.
No, I will not.
Okay.
But even so, that makes me feel better that even if, because sometimes the people on the other end of the phone are just phone jockeys or maybe kind of a little on the ding dong side. So if somebody were to fat finger the name of my trust and called it the Evers Trust,
right?
But all the activity can be proved that it was done by me as the trustee, I'm safe.
Yep. Yeah.
Okay.
Yep. Yeah. Because again, it's the name's important, who the trustee is important, the date. We all use that as the identification, but in reality, it's tied to your Social Security number.
Okay.
And if you have an account at Fidelity, it's tied to your Social Security
number.
And if you have an account at the bank, it's tied to your Social Security
Why do the banks have such a problem with the irrevocable trust? Some of them will not give me an account.
Banks suck.
They do. That's true for real estate mortgages too. Yes. Just so everybody knows.
You could walk into the same bank one day, talk to someone, and they tell you one thing, and walk into the same bank the next day, talk to someone else, and they'll tell you something completely different. Like one of my favorite pastimes whenever I go to my bank is just listening to all the bad advice that I hear from people. Like I hear, and it's legal advice. Like they're telling them, oh, you can just name someone joint on your account. That's how you can avoid probate. Or I've had clients who, so one of the things we tell our clients is like your checking and savings account should have transfer on death or payable on death, like beneficiary designation.
Yeah.
Because a lot of times people forget about that in terms of funding the trust.
Yeah.
And so it's just a beneficiary designation. But you walk into one bank and you say, hey, I want to add a transfer on death designation. They're like, what? I want to add a payable on death designation. I'm like, oh, okay.
Yeah.
It's just banks, and everyone's a vice president, and they've been there 3 months, and they change around and stuff. So
yes.
I could go on and on. But banks are notorious for
senior
giving a hard
mortgage
time.
Specialist.
Yeah. And that's why our document, especially our financial power of attorney document, it's about 20 pages because we need to specifically show every little thing that you can do. So if someone at the bank or the legal department says, hey, no, you can't change that beneficiary, we point to, section 3.19 says specifically I can do that. Like I actually had that as a problem. We had a client who, hypothetical client who, mom was in a nursing home and there's a life insurance policy with dad. And we want to make sure if dad passed away, the life insurance policy doesn't go to mom who's in the nursing home. And so we're working with one of the big financial institutions and we're having the kid make the change with the power of attorney. And they said, the power of attorney doesn't give you the authority to do that. And then I got on with the legal department and I said, section 3.19 specifically says that we can do that. We're like, oh, I didn't read that far. I'm like, what are we doing here?
Right.
Like, why?
You're the legal department to boot.
Yeah, that's your job to do that. So, we get a lot of weird stuff from banks, and we just tell our clients to give us a call, and we can usually work it out or talk to someone who knows what they're doing.
Yeah, that's crazy. How long have you been doing this?
16 years.
All right.
Yeah.
So, I mean, there's a lot. We have covered a lot. What is like the easiest thing somebody could do?
contact an estate planning attorney.
And let's say they're not going to do that. What's the next easy thing? Like, is there any armchair Johnny homeowner shit that actually works or sticks?
No, that's where I refer to the probate attorney who has to clean up the mess.
Yeah.
Yeah, you can download. You don't need an attorney. You can write your own will. You can download whatever forms you want.
Same with real estate.
Yeah.
You can do it yourself.
Yeah.
Good luck with your results.
Yeah, and good luck. Like it may work out, but having done this for 16 years and seeing all the things that go wrong, even working with attorneys who might not specialize in this area.
Yes.
Like I would never review like a real estate deal. Like there's not a chance in heck. Just like I wouldn't represent you if you got a DUI. I have no idea.
Yeah.
Like I have a very deep knowledge here, but I don't know these other areas of law.
Yes.
So I see a lot of attorneys that say they do criminal law and estate planning and divorces. I'm
Yes.
like, how are you smart enough to do all this?
You jack of all, master of none.
Yeah. But yeah, so I don't have, hey, go to Staples and get yourself a living trust kit. Like I just see so many mistakes.
Yeah, I think the mistakes come from people not really knowing 100% what they're actually doing, what an actual living trust is, or what a will does.
Yeah, yeah, and really, and I think it's for both of our professions. It's not just here's a house or here's a estate plan. It's the counseling that goes along. And I think this is in all areas of service. Is there's a commoditization, like you can go online and find a house. Why do I need a realtor?
Yes.
I can download a trust. Why do I need a attorney? So the value we provide as professionals is not the tool or what they're buying. It's the counseling. Yep. And the strategy to get there.
Yes. The strategy and understanding the nuances of their legal documents. And I can't give legal advice. Right. But helping my client understand how this contract works is critical. All right. You had mentioned in this, and I'm coming to the end here. I feel like I just keep trying to eke out more information while I've got the chance.
You're on the clock. I'm going to send your bill.
I know. That's fine. Invoice me.
Yeah, I'm joking.
Radio show. You have a radio show? Can we plug that? Okay. And can we make sure before you leave to get your links in the show notes so anybody listening can go find you easily?
Sure. Yeah.
Beautiful. What is your show?
Yeah. It's creatively called The Chris Berry Show.
I like that. It's
kind of like Dave Matthews Band.
I like that. I like the Dave Matthews rep.
Yeah.
Too.
Airs every Sunday at 1:00.
Where?
On AM 1600.
AM 16. And just so you guys know, it's berry like a strawberry.
Yes. BERRY.
AM 1600. And so you talk about all these things.
We do.
I love it.
Yep. And then website we have is michiganestateplanning.com or castlewealthgroup.com. But michiganestateplanning.com has a bunch of blog posts and a lot of information on different things like Ladybird Deeds. And also we have a YouTube channel at Castle Wealth Group where we have little tidbits, 3-minute little bites on what is a Ladybird Deed or what's a power of attorney or should I deed my house to the trust, things like that. Awesome. Just because I've been doing this for so long and I get the same questions over and over again. So I was like, might as well just record it and I can send it over and here's the answer.
Yeah, 100%. Yeah. I do the same thing with real estate.
Yes.
Well, dang. What else? You got any parting, no pressure, but what are your parting words, Chris?
It's not fun to think about death, taxes, and incapacity, but it happens to the best of us. And the sooner you start thinking about it, the more options you're going to have and the better results you're going to have. And it's not about having millions of dollars, but it's about that legacy. And just like my uncle who had nothing in a $10,000 life insurance policy, it created a mess and it ripped a family apart. And we're still feeling the effects 30 years later. Yeah. All over a $10,000 policy. It sounds stupid, but it's just sloppy planning. Yeah. And it's all about the legacy you want to leave.
100%. I love it. And I can tell you, after having had the conversation, I go forth with confidence, knowing for sure how my shit is going to play out. And there's some, I could not put a dollar figure on that. It's something I didn't have before.
Right. It's creating your own rule book versus relying on the government's rule book.
Yeah. Awesome. Thank you so much for joining me today and for sharing all of the things.
Sure. My pleasure. Thank you so much.
Your brain there's a lot of information in there. Thanks for letting me pick around.
Sure.
The info given is current as of this recording, but remember, The market changes and real estate is hyper local.